Ready? Start. The object of keeping such a wide power with this court has been to see that injustice is not perpetuated or perpetrated by decisions of courts below. More so, there should be a question of law of general public importance or a decision which shocks the conscience of the court are some of the prime requisites for grant of special leave. Thus, unless it is shown that exceptional and special circumstances exist, that substantial and grave injustice has been done, and that the case in question presents features are sufficient gravity warranting review of the decision appealed against. Such exercise should not be done. Para. The power under Article 136 cannot be used to short circuit the legal procedure prescribed in overriding power. This court generally does not permit a party to bypass the normal procedure of appeal or reference to the High Court unless a question of principle of great importance arises. It has to be exercised exceptionally and with caution, and only in such an extraordinary situation. More so, such power is to be exercised taking into consideration the well established principles which govern the exercise of overriding constitutional powers. It is true that this court, when exercises its discretionary power under Article 136 or passes any other under Article 142, it does so with great care and due circumspection. But when we are settling the law in exercise of this court's discretion, such law so settled should be clear and become operational instead of being kept vague, so that it could become a binding precedent in all similar cases to arise in future. It has been canvassed before us that under Article 142 of the Constitution, this court is competent to pass any order to do complete justice between the parties and grant decree of divorce, even if the case may not meet the requirement of statutory provisions. The instant case presents special features warranting exercise of such power. We are fully alive of the fact that this court has been exercising the power under Article 142 of the Constitution for dissolution of marriage, where the court finds that Mary's is totally unworkable, emotionally dead, beyond salvage, and has broken down irretrievably, even if the facts of the case do not provide a ground in law on which the divorce could be granted. The defense plea that PW2 had received the injuries on the evening of June 23rd and not in the morning of June 24th gains credence from the fact that an incident between the two sides had admittedly taken place on the evening of June 23rd, 1995. In the face of this admitted position and the medical evidence, it is difficult to accept that the injuries found on the person of PW2 were received by him in the morning of June 24. From this, either of two interface would logically follow. One, PW2 was not present at the occurrence in which the deceased was killed in the morning. The occurrence in which the deceased was killed did not take place in the morning of June 24, and he was not killed in the manner as suggested by the prosecution. Both the inferences are equally damaging to the prosecution case. In view of the facts and the circumstances, it would be highly unsafe to upload and sustain the appellant's conviction for the offense of murder, and the prudent and safe course would be to give him the benefit of doubt. Accordingly, he is acquitted of the charges under section 302 and 324 IPC. The next appeal is directed against the judgment of the Punjab and Haryana High Court in Criminal Appeals numbers 201 of 1996, confirming the appellant's conviction under section 302 of the Penal Code and the sentence of life imprisonment awarded to him by the trial court for having committed the murder of Kamlesh. Para. In his statement before the police, he said that in the morning he, along with his two younger brothers, Ram Kumar, PW6, and Kamlesh, the deceased, was sitting on the chabutra of their Baithak in village Kesopur when Kamlesh proceeded for his house to bring the clothes for getting ready to go to Faridpur, where he was due to appear in the BA examination. As he reached the Chaupal where the lane turned, he was waylaid by the accused Karam and Rampal, who were armed with knives. As to the cause of the incident, He started that shortly before the occurrence his younger brother Suresh was elected as the village sarpanch. He did not pay any heed to his demands. Stop.